I want to move to the CLE portion of our discussion today because I want to make sure we have adequate time for this. Our speakers today are Peter Birnbaum and Christine Sparks. Peter Birnbaum is a person who makes us and our profession look good. Among his many accolades, he served as president and chief executive officer of ATG since 1991. Under his leadership, the company's developed into a leading lawyer service organization with annual revenues in excess of $100 million. In 2015, Peter received the Justice John Paul Stevens Award for those who exemplify the justice's commitment to integrity and public service in the practice of law. In 2014, Peter was proud to receive the Illinois Bar Foundation Distinguished Award for Excellence. In 2011, he was inducted as a laureate in the Academy of Illinois Lawyers, which is the highest honor bestowed by the Illinois State Bar Association. In 2013, he received the Chicago Bar Association Vanguard Award for promoting diversity in the profession, and he previously had received the Abraham Lincoln Mervitz Lend a Hand Foundation Making a Difference Award. He holds or has held leadership positions on several corporate and philanthropic boards. He served as president of Big Brothers Big Sisters of Metropolitan Chicago. He and his wife Juliet have been a big brother and big sister for more than 18 years. He's currently president of the Jesse White Foundation and led the effort to build the Jesse White Community Center in 2014. Past president of the Alumni Board and current Board of Overseers member of Chicago-Kent College of Law. He was honored with a Distinguished Service Award from the college in 2004. In 2013, he was named as one of Chicago-Kent College of Law's 125 alumni of distinction of its 125-year history for his outstanding professional and community service achievements. He was elected to the Board of American Land Title Association in 2009 and recently completed his term as treasurer. In 2004, he was appointed judge to the 7-member Illinois Court of Claims, which hears cases en banc and rules on claims against the state. He was appointed Chief Justice in 2015, and he must have been doing a fairly decent job because Rauner appointed him again in February of this year. Christine Sparks is Vice President and Managing Attorney Claims and Audit for Chicago, Illinois, ATG. She joined ATG in 2003. She assesses the insurability of real estate transactions as they relate to claims analysis. Her duties include investigating and resolving title insurance claims. She also provides direction and support to the audit department personnel in resolving member audit compliance issues. She's a recipient of the Stanley Marion Real Estate Law Fellowship, an active member of the Illinois Land Title Association. As a matter of fact, she recently completed her term as president of the ILTA. I'm going to turn this over to Peter and invite him to give us some background and information as to what's going on with the legislative initiative that's represented by SB 2688, where we're going, what are the trends in the profession, and what do we need to be aware of. Without further ado, Peter Birnbaum.
Thank you, Ralph, and it's great to see everybody this morning. Today, since we're close to Halloween, I thought we would talk about the ghosts of the past, the ghosts of the present, and the ghosts of the future. I've always loved that line. It's not Carlos Santana, it's the other guy. Those who cannot remember the past are condemned to repeat it. That has relevance to this conversation today. And there's also some history with lawyers providing title services in Illinois over the years, how we got to where we are today, and what I think we need to do to protect our futures. So the theme, going along with the ghosts of the past, is, it says screwed, but it's how to not get screwed. How do we avoid losing our practices? How did we get to where we are today? Are the current market practices sustainable? And then third, how do we prepare for the future? So I don't want this to be a ATG infomercial. but I do need to talk a little bit about the history of lawyers providing title services in Illinois, and by necessity, that requires some discussion of ATG's history, because we were really at the outset of that phenomenon. So we were founded in 1964 by a group of downstate lawyers. That guy, Stan Ballback. Prior to 64, lawyers wrote title opinions, but they weren't in the title insurance business. And starting probably in the late 50s to early 60s, the national title companies started moving mainly from the West Coast to the East. And when they would come into a new market, the phenomenon that we saw was that the title company and the realtors would say, well, you don't need a lawyer anymore because you've got the title company and it gives you more protection than a lawyer's opinion, and we can do the closing, or you can do the closing at the bank, or the realtor could prepare the papers, and you really don't need a lawyer anymore. So the lawyers, the real estate lawyers back then, took great offense to that. So the conversation that we had in 1964 is the same conversation that we would have today, which is the sale or purchase of a home is the largest financial transaction of a consumer's life. It's stressful, it's complicated, it's baffling. Consumers are largely unaware of the nuances involved, particularly from a documentation side. If anything, it's only gotten more complicated. And we believe, and I know that everybody in this room believes, that consumers are well served by having a lawyer represent their interests in that transaction. So the vision, and again, it just happens to be ATG, but I'm just trying to give you context of how we got to be where we are today. Okay. So the idea was, if the title companies are trying to put the lawyers out of business, why don't we form our own title insurance underwriter, and then we can compete. So the idea also was that if we were successful in raising the money, which we were, in building a guarantee fund, that lawyers could continue to represent clients in residential real estate transactions by complementing their legal services with title services. Our original logo that was designed by a lawyer from Canton, Illinois at a board meeting was the best of both worlds, because it was lawyer representation supplemented by title insurance. Being a member-owned and member services company, one of the things, rather than having to be accountable to Wall Street, we only had to be accountable to our members, many of whom are here in this room, many of whom were these original folks that put up the money to start the guarantee fund. And being member-owned means we represent you. This is our constituency, and our mandate has been, and I think always will be, advocacy for the lawyer, advocacy for the lawyer in the legislature, in the media, in public relations. That's our job, to get our message out there. So this is hard to believe.
Do you want to use this one?
No,
Then you can walk.
might be better. Okay, what's that? What's that? Okay, better. Okay. So when I started at ATG in 1981, we had 4 employees, and one of the first things that my boss at that time, Doug Miles, gave to me was the Alta News. I don't know if anybody subscribed to that, but it's the ALTA monthly magazine. And he said, you know, he was training me to go out and meet with people like John Haas over here and explain how ATG worked and why we didn't have Alta forms. We had forms that said the same as Alta. And he said, well, we're not allowed to be members of Alta. And in fact, I want you to read this article that just came out in the ALTA News about our business, and I think you'd find it instructive. So the general counsel from Alta writes this article called The Saga of the Bar Funds. I was looking at it last night, and I took out a quote that I thought was particularly relevant. And it says, like a chronic infection, the bar fund movement has resisted all of our efforts to eradicate it, and if left to fester, could ultimately contaminate the entire commercial title insurance market. Wow, that's crazy. I mean, it's like, really? When I went on the Alta board, I said that I felt like Rosa Parks at a Klan rally. Like, how did I get here? So it's that backdrop that sort of shows where this business started. And it's this backdrop that has great influence on my perspective of where we're at today. So as difficult it is to believe, having ISBA past president John O'Brien here today, when we first started, we weren't allowed to go to ISBA meetings or ABA meetings because the attitude of the ISBA was, and the ABA, we really don't want to get the commercial title companies mad at us because we get a lot of claims work and so forth. So we just as soon you not have a booth at the ISBA meeting. Early on in my career, two of the things that we faced, both while I was still in law school, was legislation that would prohibit statutorily lawyers from providing title services. And the other, incredibly, was an antitrust suit brought by Chicago Title against us. And at that time, and going back to that article in the Bar News, or Alta News, the fear of the commercial title industry was if the lawyers get into this business, they might take it over. So we were sued for antitrust by Chicago Title in the early 80s, and they had, at that time, something like 96.2% of the market, and we had 0.00001% of the market. So we won that. Many of you here will remember, I see quite a few in the room, price wars. Anybody remember that? So price wars was sort of the last shot at us. Late 80s, early 90s, Chicago Title dropped their prices of retail title insurance overnight by 40%. The theory being that if we take those prices down, it'll take the money out of it for the lawyers, and the lawyers will give up and we'll win. And it's funny, at that time, and I see a lot of the faces in this room that were there in those days, we would have these town hall meetings, and people would say, we're in this for the long haul, this is really bad, doesn't matter if we're not making any money right now, we have to take the long view and win this, because this is really a battle for our practices. And that's really foreshadowing of what I'm going to say in a couple of minutes. So we won. We won the price wars. We actually gained market share during those years because the lawyers were so angry and so, excuse me, emboldened that everybody back in those days said, the heck with it. We've got to win this. So we won, and with that came the emergence of competition. And competition is good, but sometimes it gets out of hand. And I want to talk about some of the market dysfunction that I see today, and I suspect it'll ring true with all of you. So how did we get to this realtor phenomenon that everybody in this room is fighting every day? How did we get there? So I had the really the good, tough, but good experience in understanding realtor-controlled business, because I was back in the day, we owned about 30 or 40% of the Colorado, Utah, and Minnesota funds, those companies. And the Minnesota fund was really interesting, particularly the Minneapolis market. And what we saw in that market was that Burnett Realty, who was the dominant realtor in sort of the Edina and suburban area in the city, and then Edina Realty, the other big realtor, they formed realtor captive title companies. And within a few short years, so the Minnesota lawyers and the Minneapolis lawyers weren't as well organized as the Illinois lawyers. And I'd like to think that a lot of it has to do with IRELA and our ability to take the experiences of others and respond to it and to respond competitively. But in Minnesota, in just a couple of years, while I was on that board, lawyers went from being in the business to not in the business, completely out of the business. So I was aware of the realtor threat and what that could mean in terms of lawyers' practices, and took that back to Illinois, and hopefully have used that experience and knowledge to respond here. But I'll just highlight a couple of the big issues. As you know, the banks and the realtors try to get into this one-stop shopping idea where you could package everything together. We were very successful in fighting that, and thank goodness. If you can imagine, if the banks, after all they went through in the mid-2000s, if they controlled every little piece of the puzzle. ISBA 94-1, something I worked on with John O'Brien to address those counties where realtors would just have a lawyer do a deed in the transaction. And then Johnny O's great moment of fame. There he is back there. Give him a hand. John has a big birthday coming up, by the way. Did you know that? A really big birthday. So happy birthday to John. But this was John's, big moment in terms of being the leader of this organization. Prior to that, I would come to this once a year, and it would be breakfast, with a couple of guys, and that was really it. And it was this issue of Koenig and Stray saying, you don't need a lawyer, we have in-house lawyers, to hell with the lawyers, that John really hit the front pages with IRELA by bringing a lawsuit against Koenig and Stray, which he prevailed in. Next came the issue of One World Title and Prudential and doing title orders and listing agreements, something that we still see today but have had success in pushing back. And then ISBA Opinion 10-2, it's in your materials. We had hoped that with that publication and saying, giving a lawyer the cover to say to a realtor, listen, I can't really do this. I can't agree to send business to you in exchange for client referrals, would be a successful defense. As we know, that's not been the case, at least to date. So today, some, and I need to emphasize that, some broker captives are real market forces, but some of the behavior of some of those brokers, in our view, is prohibited by law, and also creates all kinds of other attendant issues. I think it's a RESPA violation, Section 8 of RESPA. If I say, Christine, I'm going to give you a client, I'm going to send business to you, legal business. If you send me title business, that quid pro quo, that exchange of value is a RESPA violation. I think there's Illinois statutory violations, but most importantly, by allowing a system to exist where a lawyer is abdicating to the broker to get business in exchange for a verbal understanding that lawyer is going to refer business back to the title company is an ethical dilemma. It's a real ethical dilemma. But it's also a financial reality. Like, what do I do? My kids have to go to college. I've got expenses. So the confluence of that dilemma with economic reality is a real pain point here. But I think in terms of the last two issues, it hurts the public because the public doesn't know. One of the things about title insurance is that consumers, it's been documented over and over, they don't really shop, at least today. We'll talk about that. They don't shop for the service. They don't really understand who's doing what. And with that secret deal is unknown to the consumer. And at the same time, as we know, title insurance prices are like this. They've doubled in the last 10 years in the Chicago metro area. So one would argue pretty rationally that and Congress found this from the beginning of the enactment of RESPA is less shopping, more kickbacks, if you will, more Section 8 violations, the higher the prices will go. And it hurts the profession. It hurts the profession to the extent that we agree with this kind of business model because, number one, you're being completely manipulated by someone and you're abdicating to that person. But it also hurts you over the long haul. If this is the business model, and if this is the business model coupled with unnecessarily high prices, I would submit to you that the future of this business looks more bleak than a future would look if we fight, because we have to shine a light on these issues. You know, many people have said to me, Peter, why are you doing all this? It's, you know, legislation, talking about this. It's legacy. It's legacy for all of us in this room. We want lawyers to be in the practice of law. We want lawyers to be in this business, doing real estate closings, providing title services, not today, but 10 years from now. And I fear that if we don't shine a light on these things, that could change. Oh. This is harder to talk about because this is talking about your money, how you get paid. But again, I think that it's really important, and from my perspective, having done this for 35 years, this is the only thing I've ever done. When I look at our past and I look at today's market, and if I look at today's market in a vacuum, and if we don't take a serious look at this and make changes, the future is going to be much more difficult to sustain. So why is that? Splits. When I started in this business, well, when we started in this business, we had a great idea, which was title insurance is what you sent to ATG. Everything else is legal services. And there's places in Illinois that lawyers still do that. If we still did that everywhere, can you imagine what a great competitive tool that would be? Is title insurance is just the insurance part. Everything else is legal services. Of course, that's changed. It's gotten to be more of a commodity. But in the race, you know, you saw the history of commercial title companies versus ATG trying to put us out of business. We finally win those battles. But ironically, today, the same companies that tried to put us out of business are now coming to us and saying, well, we're just like ATG, except we'll give you more dough. And then the next salesperson comes in and says, well, we're just like those guys, but we'll give you even more dough and more dough. So today, it's not unusual for us to see and for you to see a salesperson come into your office and say, we'll give you 100% of the premium, and then we'll make up for it on the closing and some other fees. And think about that. If you're getting 100% of the premium, what's the insurance company doing for its reserves? What's it doing for its operating expenses? That's what insurance companies do. That's what underwriters do. So 100% of the premium is on its face, or even 90. It's not sustainable. It's not realistic. So, but how does it work? The only way that makes economic sense is for prices to go way up, for closing fees to be through the roof, and to see junk fees. You know, look at these disclosure statements, and there's, it reminds me a lot, and we should take note of this. It reminds me a lot of the lenders in 2004, 2005. You'd start to get these deals and try to make sense of them. And you would see junk fees and why are they doing this? And some of that resonates today. And again, prices, consumer prices for title insurance in 10 years on average have gone from, buyer and seller included, $2,000 to $4,000 approximately. So just because I say this and put it up on the board, there are some who would say, why are you doing this? Come on, man, you know, it's going pretty good. And yeah, it is, but to me, too good to be true is too good to be true. So we need to embrace the fact and own the fact that there's dysfunctionality in the market that needs to be addressed. We need to have the water in the harbor needs to be more level. So Senate Bill 2688, sponsored by Senator Mike Conley, tries to address the realtor-controlled business issue, and it tries to address some of the pricing issues where we're splitting fees with our agents that are in excess of our reserves and capital requirements. And why do you have to go to the legislature to do that? You have to go to the legislature to do that because the market is not correcting itself. The market is not correcting itself. And believe me, we've tried, going through files the last couple of days, looking at this issue. You can see battles that we've had on the realtor-controlled business issue here going back to 1996 when Burnett first came to Illinois. So the market's not correcting itself, and that's why we turn to the legislature. And the bill, and Christine's going to talk about the politics, but in addition to the politics, none of this is going to work unless we have a regulator who cares, who wants to fix this stuff. So there's been no regulator in Illinois. It's been literally an empty seat for 2 years. And finally, just last week, the governor appointed a regulator for our industry, and she's sitting right there. Could you stand up, Trish? So this is Trish Cook, new sheriff in town. So Trish has both been in the title business, but more importantly, she was the chief of staff for Senator Conley, which is how she wound up getting interested in taking on a bigger role in the industry. And it really comes down to, legislation is fine, but those are just words. You need a good regulator and somebody who cares. So Christine will talk more about this. And I also want to talk about a conversation about who are your friends and who are not your friends. Ouch. So, this is you, and this is some other guys. So some of the other guys are really important to this conversation in terms of why we need to fix this problem, why we need to address this problem. So as Ralph mentioned, I was on the ALTA board for like 5 years, and it was a bizarre experience. Like I say, Rosa Parks at the Klan rally kind of thing. But I learned a lot, and I developed a lot of good relationships with people through that experience. So my Alta experience has been very positive. They do a lot of really good things. But when it comes to this issue, lawyers in the title business, it's still sort of you're the vermin that needs to be eradicated. So let's assume that I'm the guy with the glasses, and that's Big McGaffer from one of the big title companies, their lawyer. And I was talking about this bill and talking about speaking here today and why I felt that he needed, the home office of a big company, needed to get in the game with this legislation and to support this issue. And what that person said, which was maddening to me, was, well, I don't think it's our problem. I think it's the lawyer's problem. I think it's the lawyer's problem. And I said, but wait, you're paying the lawyers. You know, you're the one who is offering these splits and offering to do all this work in terms of the preparation of the commitment, and not requiring the lawyer to have E&O insurance and not requiring audits. Seems like this is your problem. And it was just like, nope, it's them. They should turn it down. They should say no. And I think that kind of shows the dysfunction here is, the reality is we're all in this boat. We're all in this boat, and we need to work together to fix this. And that's going to be my mission and Christine's mission. Hers is harder because she actually has to go and sit with all the land title folks and negotiate, but we've all got to get in the boat and effectuate change. So just to show a dramatic illustration of what I'm talking about in terms of where we've been and where we're going and legacy, sort of back of the napkin analysis of premiums just at ATG since inception is that lawyers have generated over $1 billion in income, over $1 billion in income just through ATG over the years. And I'd like that to continue. I want that to continue. I want lawyers to continue to be in this business because I think having a lawyer in the transaction and providing title insurance services is the best of both worlds. The mantra, if you try to think about the long term, I found this quote, doing good is good business if you're in it for the long term. It's a great quote. You know who said that? The chairman of BP Amoco. And he said that because he was in the soup, right? Like, oh my God, Like, what did we do? This looks really expensive. So he got religion and has adopted this view. And before we start leaking oil, I'd like us to do the same. So a couple of things. So the future. So what do we do? I'm not like pro big government guy and that the government's going to save us from ourselves in most cases. But when a market is completely and totally dysfunctional and unable to self-correct, you need regulation. And not only do you need regulation, you need enforcement. So having a framework that gives us rules we can play by, I think, is important. Two, and this is a speech that I've given for 35 years, and it's only become more dramatic in terms of the tail wagging the dog. But I can remember 30 years ago saying, come on, you guys, you know, you're charging $250 for a closing, and you're getting $300 for doing the title work, and that's backwards. Shouldn't you be charging $500 to do the closing and $200 for the title work? Well, think about today. What's the relationship between your title revenue and your legal services, and what do you spend more time on, and what's priced more properly? So the whole package of what you're being paid is fair. It's really just how do you get there? And I would love to see some equilibrium where attorney's fees go up and title insurance prices start to level out. And then finally, consumer education. I've talked to some of you about this. You know, if we really want to be disruptive, and I think we could be disruptive, is we need to give you tools so you can market to consumers directly. Give consumers the tools that they need to manage a transaction. And it's doable. If you look at Quicken Loans and Rocket Mortgage, they're soon to be the biggest lender in the country. And that's a direct-to-consumer approach, and we could do a similar thing with legal services and title services and have the consumer manage the transaction with you. I want to touch on a couple of things that you hear about a lot. I sort of might have had a little bit of an ostrich approach to this at first, viscerally, because we fought so hard with lenders to get them to accept our policies, and the seller pays and blah, blah, blah. And shouldn't let the lender interfere with the relationship between the lawyer and providing title services. But the world has changed in that regard in terms of how lenders view third-party vendors. A lot of this comes out of the foreclosure crisis, of course, where they relied on third parties to be involved in processing the foreclosure and defaults and bankruptcies and so forth, and lenders wound up getting into long-term agreements with the Justice Department over managing third-party vendors. That's coming. It's actually here, but it's coming in a way that you're going to see it more and more over time, which is the Wells Fargos of the world. Look what just happened to them over this issue with the credit cards. The chairman of the board, the long-term person, resigned this weekend over that issue. And we can tell you, Christine and Hank's here somewhere. There he is. Christine and Hank spend a lot of their time, and so do the other title company folks in this room, a lot of their time talking to these lenders about compliance-related issues, and that's going to have an impact on you. So when you start to hear things like when we come and meet with you to do your annual checkup and talk to you about services and new processes and how to use resource and so on and so forth, disclosure forms. One of the things that Christine's group is going to be talking to you, if she hasn't already, about things like cybercrime. How many here have had a friend or anybody they know involved in a theft of funds in a real estate deal? Lots. I get calls on this almost once a week. Fortunately, it's not you screwed up and the money got stolen. It's usually like, we need an expert in a case on what the standard of care is for the protection of funds. I always decline those, by the way. But law firms, title companies, brokers are especially vulnerable to cyber attack because so many folks that are in small practices or small real estate offices or small title agencies, they're using Gmail and Yahoo and that kind of thing. And if you're using public domain email, it's an invitation for wire theft. Encryption, all this stuff is really, really important because oftentimes if the money's gone, you don't have a defense with the bank. If you had set, with a wire transfer, particularly if you set in motion those things that enable the theft of those funds through a rerouting, you're going to be on the hook. So the last thing I want to say, I've always loved this phrase because it's about, rather than pointing at others and saying what's wrong with them, the doctor saying what's wrong with the patient, sometimes the doctor has to look at their own practice and say, we need to change. Medicine needs to change. And I think that the same holds true of all of us in this room. And I know there's title company people here, there's lawyers, there's bankers, there's people from all walks of life at this meeting this morning. So I would say that phrase, physician heal thyself, has equal application to us at the title company, to you in your law practice, to you at the banking institutions, to you at the real estate brokerage office. We need to shine a light on the market. We need to shine a light on our practices, and we need to work together to change the things that need to be changed for the betterment of your clients, for the betterment of consumers overall, and for the future of your practices. So, kind of a bummer topic today, but it's something that I feel that I need to say and for us to get on the table so we can work through these issues. So thanks for having me, and I'm going to turn it over to Christine.
Hello. Okay, so I'm going to, like Peter said, talk about the politics, but I'm going to start taking a step back and looking at the legislation itself. And so in your blue folders, there should be a copy of the Senate bill if you haven't come across it already. And I'm going to talk about it a little bit out of order, but I want to discuss the specific sections of it so you can see where we're coming from. So we're talking about this all conceptually, and that the market is not functioning, and it's not correcting itself, and that's what this legislation's trying to address. So there are three, I categorize it into three groups. So the first you have on is section 21, and it's an amendment to A6. And that section is really dealing with RESPA, right? So that there's a RESPA violation. And like Peter mentioned, it's pretty clear to most that some of the marketplace issues that are taking place are a RESPA violation. And what this section is specifically doing is addressing that and also saying that anybody who accepts a title order with knowledge that the order was placed by a settlement service provider or lawyer in exchange for the express or implicit promise that a consumer will be referred to that provider for settlement or legal services in exchange for title order. So it's saying that that can't happen, right? And I think Peter emphasized that the position is not that all affiliated companies are a problem, but how those affiliated companies are run, how they go about having that order placed with their affiliated company is important. And we are seeing in the marketplace that it's not always done in a way that protects the consumers. So you're seeing it sometimes being put in the listing contract. And people keep saying in response to that, well, but the consumer knows. They're signing it. They didn't have to sign it. They know. And I think you guys all know firsthand from the whole attorney modification process that you go through that consumers are probably not looking at much more than what the purchase price is, right? What earnest money they have to have, what their contingency periods are. They probably don't understand what title insurance is. And if they did, it wouldn't really mean anything to them who that title insurance order was going to. So that's what that section addresses. Then there's an addition of section 18 and 19. And this is kind of two sides of the same issue. So it's that a title insurance agent cannot remit to an underwriter, and an underwriter cannot accept from an agent a portion of the premium that doesn't bear any reasonable relationship to the work that they're actually doing, so that it has to be reasonable for that. And then the final section, going now back towards the beginning, is empowering in section 12, empowering the IDFPR to look at agents directly. So right now, in order to examine an agent, the IDFPR has to go through the underwriter. So they have to have good cause and go to the underwriter to go examine stuff. Certainly, our position at ATG is to advocate for the lawyers, and we don't want people coming into your office just to disrupt you. But there is an issue with a lot of what is taking place with these splits and these referrals and the mandatory handling of orders to a specific title company isn't necessarily evident on the underwriter level. So the IDFPR audits underwriters, but not agents directly. So this is giving underwriters, if they need, or the IDFPR, if they need to collect evidence, an avenue to go to agents directly. Certainly, if you talk to the IDFPR, and I'm sure Trish will learn this firsthand really soon, they don't have the staff to be in your office every day. That's not the idea behind this. It's not to have them come in and examine what you're doing and finding what you're doing wrong, but really empowering to correct these marketplace issues that nobody is looking at right now. And a big important part of the politics is that everybody knows nobody is looking at it right now. And that is why we're seeing so much of it rampant in the market. So those are the main changes of the bill itself. As Peter and Ralph mentioned, I was really fortunate to have spent the past year, my term ended in July, as the president of the Illinois Land Title Association. And one thing that I think becomes very clear from that experience is that the title industry is very diverse, right? The membership of that is made up of people who are direct operations. It's made up of attorney agents, non-attorney agents, agencies in the Chicago metro area, agencies all over the state, agencies, people who work on the agency side at national underwriters. And if you think about that diverse group and how everybody's interests are clearly not going to be aligned on all the issues that come up, it becomes clear, I think, why we're having an issue of the market not regulating itself. So you have different business positions, and keeping in mind that this legislation is really an attempt to keep the market functioning, where it's not correcting itself Something needs to change, and it doesn't seem likely that the industry is going to fix itself with what's going on. One of the things that is discussed when we're talking about this legislation at more of an industry level is, what is the real problem with this? Why is all of this happening in the marketplace and what's going on? And the one thing that I think everybody can agree on, maybe not to the degree that we at ATG feel this, but I think everybody can agree that the market isn't functioning right now. And that regardless of where you think split levels should be at or what work different people should be doing, I think everybody can agree it shouldn't be at 0%, right? That something needs to change there. Another thing that we hear regarding this legislation relatively frequently is that this is a Chicago metro area problem. And to some degree, it really is, right? If you go south of I-80, you see a dramatic decrease in both the closing fee and the premium. You're also not seeing actually that much of a dramatic increase in attorney's fees. I will say you haven't seen that necessarily, but there is a huge difference. And one of the things that you hear in response to that is in the Chicago market, it costs more to do business. And certainly it does. I would argue that it doesn't cost that much more to do business in the Chicago market than that, but it is something that you're seeing. So if you're seeing the difference, the disparity in the prices in the Chicago metro area, why does it matter to agents who are outside of Chicago, Cook, and the Collier counties? And one of the things that has changed recently, I will say over the past year or so, is a concern by agents throughout the state that there is a serious reputational issue for title insurance as a whole and the role of title agents. Right? If you are looking at what is going on in Illinois, and frankly, the attention to Illinois is huge right now. It's a good market to be in. If you're a title insurance agent or a title underwriter, there's a lot of money to be had. You're seeing a lot of underwriters come to Illinois that were never here before. If you go back a few years, they weren't active within Illinois, but now everybody wants a piece of the Chicago market. But is it sustainable to say that what is the value of title insurance if you're giving away such a large percentage of the premium? And Peter addressed how we're getting around that, right? So of course there are costs to doing business, and that's why you're seeing all these addition of junk fees and closing fees increasing dramatically. And for most of my almost 13 years at ATG, I've been working on claims. So I have firsthand experience with what the value of title insurance is. I see every day as we're setting reserves for claims or paying out claims to insureds or paying attorney's fees for insureds, or more importantly, talking to insureds on the phone who have no idea what they're supposed to be doing because what seems like a small claim to me is really the end of their world. It's often that people are crying because they're upset they don't know what to do, and my attorney says something, I have title insurance, I should call you. So it's very evident to me what the value is of title insurance. But frankly, if you have an industry that is giving away all of the premium, what does that do to the public perception of what it is? Clearly, I personally believe title insurance has value. I think probably everybody in this room does. Lenders do. Lenders aren't going to close a transaction without premium. But if you don't have educated consumers, they might not be feeling the same way. I went and met last year with my state senator to talk about a title industry bill, not this one, but to talk to her about a title industry bill. And I was trying to explain it to her. It was a relatively not complicated bill. And she goes, I'm just going to stop you. You know what your real problem is? Nobody cares about title insurance and nobody understands what you're talking about. And that's true for consumers too. It's a protection that has a lot of value, but I think there's a general lack of understanding about what that value is that people are getting. And if you're giving away premiums that are so high, underwriters, how are they even meeting their statutory requirement to reserve 12.5 cents per thousand that they have for claims? So this is a realization that we have come to, that the market isn't fixing itself, that there are too many diverse interests. Do you need me? No, okay. There's too many diverse interests within the industry for it to fix itself on its own. We're seeing prices that continually skyrocket. And like Peter said, if it's too good to be true, it probably is. And there's a point at which this is not sustainable. And we would argue that we're approaching that point. And Peter also mentioned about regulation, and that it's not inherently, regulation is not what we first go to, right, to fix a problem. And everybody who is in this room has been living with TRID and the new closing disclosure for the past year. And I'm the first to say that that has certainly increased cost and time and everything that is going on, which one part of it is fees are going to rise as compliance costs increase. Certainly our compliance requirements are going up. I have continual conference calls with several lenders on a regular, either biweekly or monthly basis, to talk about various things that they're looking at. They will give me a report of, this is how many agents you have and who they are who didn't remit their policy within 30 days like we require. These are how many documents we haven't gotten that should be recorded. How many claims do you have? How much of your claims is our percentage? So certainly all of this is going to increase cost, but I would argue that it doesn't increase it to the level that we're seeing, and it's certainly increasing it on the lender side. But that being said, even though we've been living with TRID for a year and the increased compliance that goes along with that, and instead of dealing with how do we prepare a RESPA, it's how do the 9 million lenders out there want their CD prepared and what's their interpretation of it, and that's been hard. And I understand the resistance to regulation, especially in light of what we have just gone through with all of that. But this is what needs to happen in order to fix the market that's not going to do it on its own. So one of the common things that I hear when I'm talking to others in our industry about this problem and about this legislation is, what the real problem is? The real problem is the attorney agents that are going on. And clearly, I would point out that it's the attorney agency programs and how they're run that are the issue that's going on. ETG has title agents throughout the state of Illinois. It's working just fine throughout the state of Illinois. But it is the constant push to get more market share with the attorney agents that is causing the problem. I often say every time I talk to an agent, there's not a week that seems to go by when they don't have somebody in their office who's offering them 1% more. And then you give them the 1% more, and then somebody else is in your office the next week offering 1% more or offering something else. And keeping in mind as an attorney, is that sustainable? What is the long-term goal of the practice? If it's keeping attorneys in the process, which I think there is tremendous value, for many reasons. If you look at case law in states where attorneys are not as involved in the real estate transaction, there's significantly more case law. It's nice from the claims perspective to have case law to refer to, but in Illinois, you don't see as much for a good reason. There's attorneys at the table who are protecting their clients. And every time I get a claim in that's on something that was or should have been disclosed on a survey, and they didn't have extended coverage because they didn't have an attorney at the closing who told them they needed extended coverage, it's horrible. It's something that most people would have in the Chicago market, but we get those claims. People who are buying a property and they don't want to hire an attorney, and having that attorney at the table to advise the client not only about contract related issues or walkthrough issues that come up, but to have them there to advocate for them, to explain title insurance is important. And I think it's crucial to keep them in the table. But if you keep getting to the point where attorney agents are getting more and more of the premium, it's not sustainable. And what's the long-term view of that? So if people keep gaining market share, are attorneys going to remain a viable part of this? And the consumer harm is also a tremendous issue. So consumers, like I said, they don't understand title insurance. And if they don't have somebody there advocating for them, they're going to be in a position where they probably don't have the coverage that they need. One of the other things that we hear in response to this legislation is, okay, but RESPA is already there, which certainly RESPA is already there. I would argue that it's not being enforced here. There's a lack of regulation in Illinois for title insurance for a variety of reasons. One of those being the staff is really small. How do you pursue these things if you don't have a lot of staff there? The other issue that we're seeing is that nobody is really coming forward with the evidence and making claims for what's happening. So when there is a mandatory referral to a certain title company, or when somebody is saying to an attorney agent, if you want to get deals anymore, you have to write title through us. The problem is that's very rarely something that's written down. Most people are smarter than writing something down than that. It's an oral conversation that's going place. Or even if they did get an email and something was written down, coming forward with that when a lot of your business referral sources are your relationships with real estate agents is a hard thing to do, right? If you are, especially if you are a younger lawyer who is starting out, building your practice, developing those relationships are crucial to your continued success. And it's a hard thing to come out and say, but you can't do that. And they will take the business away. You won't get those deals anymore. So that's why this bill is specifically addressing that. The long-term view is really important. Peter touched on that a couple of times, but keeping lawyers in this long term is really important. You know, it is amazing to me some of the sales tactics that we hear about on a regular basis. So as those of you who are ATG agents know, you've probably been through an ATG audit, which is really more of a touch point to come into your office, say, this is what we're seeing in the market. These are things that you should be implementing in your office. You should be worried about cybercrime. These are the types of things that we're seeing. These are what we're seeing from lenders, mainly so that you're never in a point where a lender doesn't want to use you because you're not in a position that they're comfortable with. What we're starting to see is other people say, if you go with them, they're going to audit you. If you go with us, we're not going to audit you. Why would you want to go with a company that's going to audit you? And that's the kind of mentality that is going on in the marketplace in general. And there's a certain standard as lawyers that I think that we need to keep in mind of making sure that we're doing things the correct way. Certainly we want everybody to be having successful businesses and successful practices that are doing well. But really starting to think about, is this sustainable in the long term? And what is the practice of attorneys going to look like in the future if the market keeps continuing the way it is and that it's not sustainable?
I have a question.
Sure.
So with this legislation, I understand. I mean, I think all of us are starting to understand that, hey, the fees that are being collected are not, it's excessive. It feels excessive. When you're at the table, it feels excessive. At least it does to me. And I wonder, so with this legislation, so it's fine, you say the split is no longer going to go to the attorney. It's still going to go to the commercial title company, I believe then. Is that, when are the fees going to come back down to where they were? You know, where you're paying $500 or $600 for a closing fee for your buyer, that seems reasonable. But now, I mean, with the fees the way they are, so what happens with this, what is the purpose of the legislation? Are you saying then that you're just stopping the split to the attorney, or then, and so if you could explain that.
It's not to stop.
Repeat the question. Just
Oh, okay. Repeat your question. So the question is, how is it going to bring prices down? How is this legislation going to bring prices down? So it's not to stop the split for the attorney, right? Attorneys and agents, regular agents, attorney agents are doing work for their clients related to the title insurance. You're reviewing search packages, you're doing work. But the idea is that percentage that you're getting, does that bear a relationship to the risk that you as an agent retain and to the risk that the underwriter is taking on, the risk for claims and various things. So it's to lower that to a more reasonable level that reflects what reality is for that risk balance that's going on. And the reason you're seeing rates keep going up is because as people are gaining market share by increasing those splits, that underwriters still have operating costs, they still have claims reserves they have to do, there's tremendous amount of compliance costs. So the rates are going up because as you give more splits away, more of a percentage of the split away, they still have to have the money to run their business, to do what they're doing, and that's pushing the prices up. So when you lower that, that brings that back down.
Yeah, but I think that it's a really good question, because if at the end of the day it's the insurance companies that just wind up making more money than it didn't accomplish anything. So the reality is, the reason that the language is what it is currently is that our governor, and this was early on in the process, has said that he doesn't like rate regulation. But in this case, it's possible that you might see it evolve into something like rate regulation, because as you say, it would be almost grotesque to have it just end up being, prices that got too high. You take away the money from the lawyers, and the insurance company pockets the difference, and the consumer never gets any benefit of that. So this is an indirect way to do that, but the reality is it may require rate regulation, which, by the way, Florida went through the exact same thing that we're going through probably 15 years ago, and they solved a lot of it by statute and by regulation, and I think that could work here, but that's the reality, is why the language is sort of loose.
But to the consumer, how is it different between the real estate title companies and the other title companies? There's lawyers, there's still fees being paid that they're not really aware of. What's the difference to the consumer?
Well, I don't think that, Peter, you can jump in here, but I don't think it's the issue inherently that these are real estate title companies, right? That it's not that all companies are run that there's a problem. It's the manner that that business is being obtained. And is the consumer knowingly going into that transaction knowing that they're choosing that person? As a person who handles claims, I can tell you that not everybody handles claims the same way. And I think when you have a client who has gone through a claim process, that probably is something that factors into who you choose. And as an attorney, if that choice is being taken away from you of where that business should go, regardless of what title company you're affiliated with, that could be a problem. Are you choosing a title company based on fees is probably one part of it, but there's more to that, right? Your relationship with underwriters. If you know who to go to, how to get a deal closed, you know who's going to be reasonable when you have an issue that comes up. And when it's being mandatorily referred before you ever get into the game and you can't get out of that contract, you're losing that opportunity as a lawyer to advocate for your client of which title company you want to use, regardless of who that is. Maybe it is the same one that was that mandatory referral, but you don't have that choice anymore.
Yeah, so, we've seen things like, a good example would be, here's the the premium for the owner's policy, but this is title company selling to lawyer. But we can add another fee on top of the owner's policy, and we're going to call it something else. But whatever we call that, you can keep it, and it's up to you. It's up to you, lawyer. This is back at this thing of who's running the show, but you'll get offered that kind of thing where it's like, here's the price, here's this additional charge that we're willing to put on, and that's another X amount of dollars for you. So that would be an example of what I would call a junk fee.
Yes, hi. Thank you. I had a question. When I talk to my insurance friends who are not in title insurance, and we talk about how we calculate fees and make underwriting decisions, they stare at me like I'm from Mars, and I'm sure some of you have had that experience as well. I'm directing this at subsections 18 and 19. How are we going to determine what is reasonably related to the exposure? Is there some expectation that math will be involved?
That math will be involved? Yes, Ellen, there will be math.
Well, that's another funny thing about Illinois, and our new regulator knows this well because it's an issue that they looked at, but or rather that Trish did when she was at Senator Connolly's offices. Illinois is one of the only states, and it may be the only state, where title insurance has zero regulation by the Department of Insurance. So a lot of the things that are normal to an insurance company in terms of rate regulation and rate filing and, how do you reserve for this or that, it's not in Illinois because it's not regulated by the Department of Insurance. So one of the things that people in government and in the industry have talked about is maybe we could merge the title insurance division into insurance because it would just be a better fit. So we'll see, but that's why you have that big disconnect. And again, the absence of math in this is really sort of a workaround based upon some of the things that the governor's office has said.
And I think Peter had also mentioned how, maybe this is going to morph into something else as time goes on. And this is really a discussion that is probably a discussion people have been having, saying things like when they get their check at the table, that people have been thinking about or discussing. But this is really an attempt to bring this to the forefront, to keep in mind what discussion do we need to be having, what steps do we need to be taking to make sure that attorneys maintain a seat at the table.
I think that, I don't know if Ralph mentioned this when he was making his introductory remarks, but in terms of having a seat at the table and being engaged, there was a hearing on Senate Bill 2688 a couple of weeks ago, and Ralph testified for IRELA, and I don't know if you sent a link of that out to your folks, but you did a great job.
We will post it.
Yeah, and then Frank Pellegrini, who's also a great advocate for lawyers.
Aurora also testified.
Aurora Austriaco from our board testified, I testified. So engagement, this is, legislation is like, sausage factories. You don't want to see how they're made really necessarily, but the fact is that with this bill, with this issue, there's lots of opportunities for us, IRELA, you individually, from a grassroots perspective, other parties can really engage. This is like taking on the gun lobby. This is not going to be as hard. The realtors are going to be hard to deal with, and you got to get past them. But you can have a voice in this.
Let me just jump in. I want to allow some time for additional questions, but I just want to point out on behalf of IRELA, we have this dual mandate to protect the practitioner and the public. And John O'Brien, from the inception of the organization, always talked about us being a big tent. We have important relationships and partnerships with lots of title insurance companies, Chicago Title, Fidelity, First American, others. But the reason I'm so happy that Peter is here and the reason that we're working on this legislation is historically ATG has always had our backs. When he talks about would like to see the attorney's fees go up, it's music to our ears, but it's in view of a long-term goal that's really important here. Think about the anomaly. I mean, damn, how often do you have a company that's in the title insurance business say, we want to have more regulation. We want somebody supervising what's going on here. Not because of what ATG is doing, but because the industry itself is kind of running amok and there isn't going to be any self-correction going on here. Everybody, if they continue taking the path of least resistance, what are we going to have? As in the position piece that you have on the table back there on behalf of IRELA, it's a house of cards. So taking the long view, which is what ATG did back in the title wars and it continues to this day, means that we're trying to protect the role of the attorney in the transaction, keep that attorney at the table. That's why we're involved. That's why we're promoting SB 2688. Other questions for Peter or for Christine?
Yeah, kind of a question based on a couple of different things that the two of you have said. First of all, if I heard correctly, the risk cost that the insurance companies are working with is 12.5 cents
That's the
per
reserve.
thousand?
That's the reserve, the statutory reserve requirement.
And presumably that reserve is going to be pretty close to the actual experience. Yet the cost, the premium is $1, $2 per thousand, depending on what you're dealing with. Mm-hmm. So there's a lot of value there. The other thing I heard was that the Illinois experience, the actual claims in title loss is much less than other places where attorneys are not involved. So it would seem that maybe there's a quantifiable value to the attorney being present at the table. And, so it's not only allegory, it's actually a quantifiable
Absolutely.
Amen.
Absolutely. I mean, that's been our mantra since the get-go, is that we've always had a lower rate of claims than other title companies because you have a lawyer representing the seller, bringing down title, and it's your client. And you say, hey, Joe, didn't you have that? I did that case, and you had a judgment, and it's not, so there's demonstrably lower claims. But if you are giving 100% of the premium, I mean, there's money being shuffled around on the table. Some of it's junk fees. That's what worries me. It's the fact that you could say, construct an argument, or it's not even an argument, it's just like a bidding war is, we'll give you the whole premium. You can't give them the whole premium. The lawyer's entitled to a lot of the premium, most of the premium. But it can't be all of the premium. But your point is well taken, and it's one of the great success stories of Illinois is how having lawyers involved in transactions helps the consumer and lowers claims. I mean, there's parts of Illinois where, I was in southern Illinois years ago, and it was actually the home of the son of one of our founders of ATG, and he had built a dock on a lake for his kids. And I said, so where's your lot line? He goes, I don't know. I said, what do you mean you don't know? He says, well, we don't get surveys. We don't get surveys here. It's just take your chances kind of thing. So.
If you've been wanting to ask a question and you're just trying to gather the courage, just a brief commercial. One, you want to make sure you fill out your evaluation form if you want credit. Two, Christine Sparks knows a thing or two about cybersecurity. Those of you who are ATG members, on November 10th, there will be the Harold Levine Real Estate Institute, and there'll be a panel discussion with Christine, Julia Bermudez of Thompson Flanagan, Scott Renfro of the ARDC, and myself. It should be a very interesting discussion. Any other questions? Let's give a round of applause to Peter and Christine.